Special Magistrate Norm Fugit. We will start, it is 1:30 p.m. on Wednesday, October 21st. We'll start this meeting with a Pledge of Allegiance, so if you will stand and join us. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Okay. We have 3 cases set for the docket today. Each one of these cases will be considered separately. I will receive evidence from the city's code enforcement department and maybe other people on behalf of the city. I will receive and hear evidence from the owners or other responsible parties or those who wish to testify. That being said, Madam Clerk, are you prepared to swear in the witnesses? So everyone that will be giving testimony today, if you would stand and raise your right hand, and the clerk will administer the oath.
Do you swear or affirm that the testimony you are about to give in this case today is the truth and the whole truth? And please state your name and address for the record. Newberry Lane? Yes, sir.
Rick Wolf, City of Newberry Code Enforcement Officer.
Okay, that's it? Okay.
Okay, do we have any remarks of staff and attorneys before we proceed?
None from staff.
Okay. Okay, our first case, we'll call our first case then. This is case number CE 2020-001. Mr. Wolf, are you ready to proceed?
Yes, I am, Your Honor.
Okay, you may.
If we can have the first slide.
Before we go to that, is this, do we have, I changed the order up sometimes to accommodate those who are present.
I think all 3 cases are represented.
Okay, then let's proceed.
Your Honor, I am Rick Wolf, a Code Enforcement Officer with the City of Newberry, and I have been duly sworn, and my credentials are on file with the Magistrate's clerk. In case CE 2020-001, the respondents are Hall and Larkin. The photographs that are being presented this afternoon into evidence accurately represent the violations as seen and were taken by myself or others if indicated on the photograph with the dates and times indicated. On the 5th day of May 2020, the City of Newberry Code Enforcement Officer received a citizen complaint on a developed mobile home lot at 25235 Northwest 8th Avenue in Newberry on tax parcel 02403-003-000. The property was inspected by me on May 5th, 2020, and was found to be within the incorporated city limits of the City of Newberry and in violation of the City of Newberry Code of Ordinances. Specifically for Chapter 14, relating to Building and Building Regulations, Article 2, Building Code Division 3, Building Permits, Section 14-101. Basically permit required. And paragraph A states it's unlawful. It shall be unlawful for any person to construct, alter, repair, remove, or demolish, or commence construction, alteration, repair, removal, or demolition of a building or structure in the city without first obtaining a formal permit from the building inspector. The property owner has allowed construction or move on of a shed without obtaining the required building permit. There appears to be an electrical service also installed to the shed. The property owner has applied for the permit but has not paid to receive the permit in question. If we could have the next slide. Your Honor, I was visiting this property with regard to another complaint about a tree that was hazardous in April, the 21st of April. And in this photograph, you can see between the mobile home on the left side and the fence to the rear, there's no structure. There's no shed. And next photograph, please. And on May 5th, I returned to the property as a result of a citizen complaint regarding a shed that has been placed on the property. And you can see between the fence and the mobile home a storage shed that has been placed on the property. Next slide. This photograph was taken in July, or June 9th. We're missing, it's up at the top. June 9th on the left and July 14th on the right. And you can notice in the photograph on the left, there appears to be a trench that has been dug from the power pole to the shed, the open area where it's sand instead of grass. Next slide, please. Your Honor, this property is vacant, is developed on a residential mixed single-family mobile home lot on approximately 0.24 acres in size. The property is homesteaded. A notice of violation 2005001 was mailed by certified mail and regular mail on September 23rd, 2020 to the owner of record as recorded in the tax collector's office and to any other additional responsible parties as code allows. The notice of hearing was also mailed by certified mail and regular mail on September 23rd, 2020. The notice of hearing was then posted on the subject property on September 29th, 2020. Just as a side point, when we have been sending out certified registered mail, the post office has not been hand delivering it and getting signatures because of COVID-19. They've just been delivering it in the mailbox and putting COVID-19 on the green card. So in all three of the cases being presented to you today, all three sites have been posted both at the property and at the City Hall Bulletin Board to provide for proof of service. And in your packet, you will get affidavits of posting for that information. Property was sent by certified mail and posting, and in that notice of violation, the respondents were given until October 13th to correct the violation, completing one or more of the following actions. The property owner was advised to obtain a proper building permit from the City of Newberry Building Department and pay a fee for all construction improvements in accordance with the Florida Building Code. Ashley Hall submitted an application for the building permit on May 21st, 2020. She was notified by telephone that the permit was ready to be picked up and fees needed to be paid. At that time, she advised me that she did not think she needed a permit and that a permit was not required for a move-on shed and that she had correspondence to that effect. I asked to receive a copy of that correspondence and she said she would be happy to show it to the judge. So as a result of my inspections on May 5th, June 9th, and July 4th, 2020, and if we go to the next slide, this is September 29th, where it was posted on the bulletin board at City Hall. And the next slide, this is October 13th, which was the deadline for obtaining the permit. And the final slide is October 20th, which was yesterday. Next slide. October 20th, which was yesterday for my re-inspection for the cases today. And again, the storage building still appears, but no permit has been paid for. As a result of my inspections, we ask that based on the preponderance of evidence, a finding of in violation occur for the respondents Hall and Larkin for the violation of Chapter 14, building regulations relating to a permit required that it's unlawful for a person to construct, alter, repair, remove, or demolish, or to commence construction, alteration, repair, removal, or demolition of a building or structure in the city without first obtaining a formal permit from the building inspector. And secondly, we ask that the respondent be given 30 days to comply as set forth in the corrective action stated in the original notice of violation, or a fine of $50 per day until compliance is achieved. And finally, that we ask that the city recover the prosecution cost of $120 for taking this through the special magistrate process.
Is that amount set forth here anywhere in my paperwork?
I do not believe that it is.
Okay.
It's in
Can you repeat that for me?
$50 per day for each day that compliance is not achieved after 30 days from the signing of the order, and $120 to recover the prosecution cost. And as mentioned, the building permit is ready to be issued. That was submitted. I believe that the fee on that is $89. And Your Honor, I would like to submit for the record a copy of the search on the City of Newberry permit process, master permit inquiry, applications for permits, master inquiry, with regard to that an application had been received, but a balance of $89 is still due. And I'll submit that for the record.
Thank you. This is a copy.
And finally, I would also like to submit copies of the photos for the record that have been shown this afternoon.
Same photos that you've shown on the screen, right?
Yes, sir.
Thank you. Anything further?
Your Honor, we do have one of the building inspectors present if you have any questions relating to that a building permit is required under Florida Building Code for a move-on shed.
I'm aware of that, and you have that same requirement that you've shown me under the code. Are you asking for a finding of a violation of the Florida Building Code also, or just the local code?
No, sir, just the local code.
Okay. But on that subject, would the proper payment for the application for the building permit, would that trigger some kind of an inspection on the part of the city?
Typically, an inspection would be done on a shed once the permit is approved, and the applicant would call for that inspection.
Okay. And this really has nothing to do with my decision, I don't think, but if there was an electric service that was installed, would that require a separate permit, or would, I'm seeing a nodding of a head, so.
It typically would require that.
An additional fee, or?
I guess it'd be best answered by the building inspector.
I see him nodding his head. Again, this is not relevant to,
Yeah, the shed permit is $89 minimum permit fee, and the same for the electric.
Got it.
It'd be $89 as well.
okay.
That concludes staff's comments.
Okay. Are there any others present for this case? Yes, if you would step forward. Yes, ma'am. Give us your name and address again for the record.
Ashley Hall, 25235 Northwest 8th Avenue.
And what was the last name?
Hall, H-A-L-L.
Okay, Ashley Hall. Okay. Okay, Ms. Hall, you've heard the testimony of the code enforcement officer. Did you understand his testimony?
Yes.
Okay, and I would ask you to respond in whatever way you would like to that.
When I purchased the shed from the shed place in Newberry, I asked them that I need a permit. They said that I did not need a permit, So when I talked to the city, I told them that I did not need a permit when I purchased it, when I was making payments on the shed. I feel like I told him, if they selling the sheds, they should be the one pulling the permit. When that tree, what I called him about, fell through my roof, when they came out to fix my roof, I didn't pull the permit, the roofing company did. So I feel as though that the shed company should have pulled the permit when I purchased it from them.
Okay, so if I'm understanding right, they told you this when you purchased the shed?
Yes, before I got the shed, I asked them, before I did financing and everything, do I need a permit? They told me no.
What have they said since then?
The same thing, that I don't need a shed,
So
that
you
I don't need a permit, that they said for the city laws, it just has to be 5 feet away from my fence.
Okay, did you, so you have talked to this, is the name of the company?
The shed company right here in Newberry, Florida.
Okay. Okay, and are they located within the city?
Yes,
Okay. Do you have, did you say you had a piece of paper or something you wanted to provide or no? No, an approach. Okay, have you provided a copy of this to anybody with the city?
No.
So, Mr. Code Enforcement, Mr. Wolf, you've not seen this? Okay. At the top, okay, this is dated May 30th of 2019. At the top is the name Tim Marden, Newberry City Commissioner, Group 4. And I assume this is a document that was created by Mr. Marden, is that right? Or
yes.
where did you get this document?
That came from the shed company,
From the
and they said that Mr. Martin wrote it.
Okay, all right. So this appears to be a communication from Mr. Marden. I assume is he still a city commissioner? Okay. And it said shed permits repealed, it says entitled shed permits repealed. Previously, residents needed variance permits costing $200 to advertise in order to place non-permanent engineered style wind-loaded structures like prefab sheds inside the 10-foot side and 15-foot rear property setbacks. Commissioners have repealed this permit.
They repealed the setback.
Yeah, I guess I would probably want to ask legal counsel, would probably be the most appropriate person, or Mr. Wolf, as to your response to what I'm reading here.
Your Honor, it sounds like it's a repeal of a section of the ordinance that relates to setback requirements for a special use permit or a variance to the setbacks, not to whether a building permit is required. The decision of who is required to get a building permit is that of the building official of the local government.
This was dated May of 2019, so just to make sure I'm understanding this, I would request, and if somebody can look for me or direct me, I think I have a copy of the city code, but if somebody can direct me to some language showing what was repealed that this commissioner may be talking about. So.
And Your Honor, I'm happy to help with this. If I have a copy of that, it may be helpful for me to look it up.
Okay.
a little bit.
That was dated May of 2019, so I'm assuming that whatever was repealed was about that time. do you need some time to be able to take a look at that?
Your Honor, what it looks like here is this is the variance cost to advertise.
Mhm.
I did just text the office as well to pull up the ordinances that were passed in April and May to get confirmation of the exact ordinance number.
All right.
But what I'm, just based off it looks like a Facebook post alone, it looks like it's saying the cost for a variance permit is what's been waived, but there's still permits required for other permanent structures.
Okay.
And Your Honor, if I might add, under the, about line 13, it says utility easements still apply, pools above and below ground, homeowner-made sheds, and other permanent structures still require permits.
Okay.
Homemade, my shed wasn't homemade.
Right, well-
I purchased it from the shed company.
I understand. So what I'm going to do is I'm going to postpone just to later in this hearing until we can find out exactly what the repeal that's being talked about here was, and then I'll bring this back up to talk about it further. Okay, so I don't want to hold everybody up while we're dealing with this one issue. So, are you okay with letting me go on to another case and then coming back to this?
Okay.
Okay. Okay, so let's move on to case number 2020-002. Mr. Wolf?
Your Honor, I'm Rick Wolf, Code Enforcement Officer with the City of Newberry, and I've been duly sworn. My credentials are on file with the Magistrate's Office, and this is case CE 2020-002, with the respondents being Noemi Lozada Garcia as the property owner and Casey Paul Salter as the responsible party. The photographs that are being presented into evidence accurately represent the violation as seen and were taken by me on the dates indicated, except for a couple which were taken by Building Inspector Gene Stockman. On the 29th of April 2020, the City of Newberry Code Enforcement Office received a citizen complaint about a developed single-family property lot located at 1137 Southwest 242nd Terrace in Newberry on tax parcel 01933-010-077. The property was inspected by myself on April 29th, 2020, and was found to be in the incorporated area of the City of Newberry and within our jurisdiction. And in violation of the City of Newberry Code of Ordinances, Chapter 14, Building and Building Regulations, Article 2, Building Code, Division 3, Building Permits, Section 14-101, required. It shall be unlawful for any person to construct, alter, repair, remove, or demolish, or to commence construction, alteration, repair, removal, or demolition of a building or structure in the city without first obtaining a formal building permit from the building inspector. And the property owner has been allowed to construct or move on a porch, which an extension of a concrete deck, and also has constructed an above-ground pool. The property owner, as of yesterday afternoon, has applied for a building permit for the above-ground pool, which is for the deck, which is currently being processed, and has advised me this morning that he will be taking down the above-ground pool and removing it. He was also issued a violation in relation to Appendix B, Land Development Regulations for minimum housing and sanitary requirements under Section 9-24-4 for care of premises. It shall be unlawful for any person or occupant of a residence, building, structure, or property to utilize the premises of such residential property for open storage of or abandoned motor vehicles, icebox, refrigerator, glass, stove, building materials, building rubbish, or other similar items. It shall be the duty and responsibility of each owner or occupant to keep the premises of such residential property clean, to remove from the premises all such abandoned items as listed above, including but not limited to weeds, dead trees, trash, garbage, etc. So if I could have the first slide. This was the property when I visited on April 29th, and Mr. Salter, as the occupant for the property, had started storing construction materials within the right-of-way of 11th in the rear common area behind his property. And you can see some construction materials, rock, and dead vegetation. Next slide. This was some, I guess, paving bricks and vegetative debris and rock that was placed in the right-of-way. Next slide. This, I believe, is ASO Deputy Theus, who in the right-of-way. Next slide. This is the opening in the fence. We were on the right-of-way of the of the 11th Road, and you can see the above-ground pool and construction materials in the property to the right. That photo was taken on May 12th, 2020. Next slide. Building Inspector Gene Stockman went to the property on May 6th and issued a stop work order for the construction that was taking place, and posted this stop work order on the property. You can see the, at this point, completed above ground pool, and on the right side of the photograph, a concrete deck and posts that had been installed for creating a rear porch addition to the property. Your Honor, the property is developed as a single-family lot zoned planned residential development, PRD, and is approximately 0.18 acres in size, and is not homesteaded at this time. It is being rented. The notice of violation 204012 was issued and mailed by certified mail on June 2nd to the owner of record as recorded in the tax collector's office, and to additional responsible parties as code allows. And the notice of hearing was mailed by certified mail and regular mail on September 23rd, 2020. The notice of hearing was also posted on the subject property and at City Hall on September 29th, 2020. So service was by both certified mail and posting on the property. In the notice of violation, the respondents were given until October 13th, 2020 to correct the violation by completing one or more of the following actions. We advise them to obtain a proper building permit for the City of Newberry Building Department for all construction improvements, and to remove all trash and debris and construction materials from the public adjacent property. Next slide, if we could, please. This slide was taken on May 6th also, in a closer view showing the extension of the concrete for the porch and the post for the addition. These two photographs were taken by Building Inspector Gene Stockman, who is present, and was the one who issued the stop work order for the failure to have a building permit. Next slide. These photos were taken on May 12th, which showed additional construction materials in the right-of-way of Southwest 11th Road. Next slide. And again on July 14th, the rock had been removed, but we still have construction materials within the right-of-way. I will note that if you look on the backside of the fence, the vegetation and debris and trash that had been placed behind the property has now been cleaned up. Next slide, please. This was taken on the day that I posted the property and posted at City Hall. Photos were taken September 29th, 2020. The construction materials are still remaining on the property and have not been removed as requested. They cannot be stored within the city right-of-way. Next slide. This was the posting of the property on September 29th for the hearing and request for hearing. And then I visited the property on October 13th, which was the day compliance was supposed to have been achieved according to the notice of violation. Again, you can see above the fence the wooden post and structure for the porch addition and a little bit of trash and debris on the sidewalk and some wood stored in, again within the construction debris in the road right away. And the final slide. This was this was another picture on the 13th of October with the material still in the right of way. And the final slide is on October 20th, which was yesterday. A contractor came forward and applied for a building permit. Red Door Homes applied for a building permit, and it is building permit 2020-0509. So once this permit would be processed, if everything is in order, this would remove the violation that is relating for the porch and porch addition. In conversations with Mr. Salter this morning, he advised that he would be removing the above ground pool. So that would make that in compliance. And if he removes the construction materials that are within the right of way and on the sidewalk, then that would be in compliance as well. But as a result of my inspections on April 29th, May 12th, July 14th, September 29th, and October 13th, and October 20th, and the inspection by the building inspector, Gene Stockman, on May 6, 2020, staff recommends a finding of in violation for the respondents, Noemi Lozada Garcia as the property owner and Casey Paul Salter as the responsible party for violation of Chapter 14 for building and building regulations for not obtaining a permit and for care of premises requirements for land development regulations and the minimum housing regulations. We recommend that the respondent be given 30 days to comply as set forth with the corrective action stated in the original notice. And to be clear, that would be removing the above ground pool, this permit being processed for the porch and deck addition, and removing all materials from the city right-of-way. And that the respondents be given 30 days to accomplish that as prescribed in the original violation, and if not complied with, a fine of $50 per day per violation until compliance is achieved. And further, that the city of Newberry recover prosecution cost of $120 for this violation. I would like to submit a copy of the building permit that has been applied for, and this would typically be processed within 30 days, so if everything is in order, this would take care of the storage shed.
The porch.
Yes, the porch, excuse me. And in addition, I would like to provide copies of the photos.
Before you do that, could we go back to the photos that were taken by Mr. Stockman?
Okay. There's the ones from May 6th and the stop recorder. And the one previous. There we go.
Okay, so Mr. Stockman, you're under oath, right? Okay, did you take the 4 photos that, or the 3 photos that we're referring to there?
Yeah.
Okay, and Mr. Wolf, did you take, were you personally responsible for taking the other photos that are shown?
Yes, I was, Your Honor.
Okay, so those photos will be omitted. Okay, do we have anybody here on behalf of the owner or responsible party? Yes, sir. Step forward. Okay, we can have your name and address for the record again.
Casey Salter, 1137 242nd Terrace, Newberry, Florida.
Okay, and what's your relation? You're not the owner of the property. What's your
I'm
relationship?
not the owner. I'm in the process of buying it. I should be the owner in the next few months, 3 or 4
Okay.
months.
All right, so you've heard the testimony of Mr. Wolf. Do you have any response to that?
Yes, it started with the I was building a simple pergola on the back and having it set on the concrete slab, not attached to the house, not attached to the actual concrete thing. It was in what they call a bucket. It sits down in it. It was not attached in any way. I have a company in town. I deal with contractors. I do business contracting all the time. Don't do home. I do business contract. And I have 6 designers on staff, an engineer on staff, and no way does building a pergola require a permit if it's not attached to the concrete or the house. Their simple answer to me was the reason why I was in violation was because it was too big. Seems like they're running they have a simple code that they use in at least the first 2 here are things we've heard today. It's just a broad code that they use to get you up here to get a permit. But in no way do I need a permit to build a pergola. I have another pergola on my property that was sitting right there that they didn't say anything about. But they said this one was simply too big. So now I've gone through the process of having to find with Rick, and after the first day, everything's been going well. It's just with COVID going on and finding a contractor, I don't own the house, so I can't come pull the permit myself. So I have to get a contractor. I've been working on this since, I finally got a contractor to come and pull a permit. I've been waiting on him for the last 3 months. I'm doing everything as quick as I can.
Okay, so let me just see if I can understand and maybe cut through this point, okay? Now, Mr. Wolf testified that the city has received an application for a permit.
Yes.
For the porch.
My research.
So let me just, without getting into that detail, do you agree that you've had somebody come down and apply for a permit?
Yes, we've applied for a permit and we're changing. It's not going to be a pergola. It's going to be a different structure now, but yes.
And Mr. Wolf has stated that if that is processed through, then that will remedy that violation.
Yes.
And you've heard Mr. Wolf ask for a 30-day period for that to happen.
Yes.
Are you okay with that, or?
As long as he says it can be processed in 30 days, I have no problem.
And I understand it's in their ball court, so.
Right.
So if it doesn't happen in 30 days.
Nothing else with COVID has happened in 30 days, but yes.
If it doesn't happen in 30 days and we come back here for enforcement and it's because the city didn't process it in time, then you'll get consideration for that. So,
Okay.
Okay. All right. So talk to me about, if you want to, talk to me about the pool.
I had no clue that you had to have a permit. Everyone in our neighborhood has a pool, and I guess that it's a Florida code. I didn't know.
All right. And Mr. Wolf has indicated that you've said that it will be removed.
Yes, sir.
So is 30 days sufficient time to either remove it or apply for a permit if that's what you wish to do?
Yes, sir.
Okay. All right. And then you've heard Mr. Wolf talk about the third component here, which is the trash and debris. And he says it's now almost all cleaned up. Is 30-day, do you understand that violation?
That one I do not. I was redoing my entire yard over a course of 3 weekends.
Right.
And that's what he started coming and giving me violations for. I was hauling it off on trailers. I had it sitting in the side yard, hauling it off on trailers as much as I could, working on it. And resodded and did everything. He told me, Mr. Wolf told me I needed a permit to resod my front yard. He told me he was going to call and give me a violation for running an illegal business out of my home because I told him I was working from home with the COVID stuff. I mean, he threw it, it's like a bad cop. He threw everything at the wall, and now we see what's stuck.
Well, I'm here on what's stuck, I guess.
Well,
So-
but
so
I mean,
let
I'm
me-
just saying, it's not just, this is what we're dealing with. We're having someone that's a nuisance during the COVID or during the COVID pandemic that's happening. You have someone, because they get a call, that's their in.
Sure.
They come out and harass, he had 3 complaints in one day, the first day it came out, for harassing people in my neighborhood.
Understand.
And
Understand.
it shouldn't be acceptable.
Right. Well, but I have no jurisdiction regarding those issues.
Okay.
What I am left with at this moment in time is that the third alleged violation is for the trash and debris in the right of way of the city.
There's no trash and debris, it's construction
Right.
equipment that
And
I gotta
supplies.
stop construction. The people, they dropped off the lumber,
Right.
and I have nothing to do with it until I get my permit, and that's what we've been waiting on for 3 months. It would have been
Okay.
done within 2 days if they haven't done stop
Okay.
construction.
If I give you 30 days to do something with it, is that sufficient time to do something?
I'm not sure, I mean, I've got to get a permit passed, then they've got to start construction. I'm not sure how long the construction's
Okay.
gonna take or when they're gonna be able to start it.
All right, but am I understanding that these are construction supplies
They're
to be
construction-
used in the construction?
Yes.
And they're on city right-of-way? Is that an issue with you, or?
They're sitting at the end of a not even a cul-de-sac, at the end of a dead end,
Uh-huh.
yes.
Okay. All right. Anything further?
I mean, the one more thing, and I had the building materials delivered and to be done and finished within, I think, 3 days of when it was delivered, and with the stop order, now I have nowhere to put it, so I don't know what else to do with it. There's nowhere to move it until we get the construction permit filed and get the construction on their timeline, get it put up.
Understand. However, I don't hear any dispute that this is right-of-way, and probably the placing it there for storage in the first place was probably the issue. However, but with all that being said, unless there's something more that I need to hear from the code enforcement, and I'm not thinking that I have any other questions, I think that the testimony and the evidence presented shows that there were violations. There were 3 violations. There was a new pool installed without a permit, so the no permit was a violation on that. There was trash and debris and these construction materials that were placed in the city's right-of-way, which is a violation of the appropriate code section. And then thirdly, there was no permit obtained ahead of time on the slab and the porch addition. So I'm going to find a violation on all 3 of those. I'm going to grant the request and recommendation of code enforcement to allow 30 days to remedy each of those violations. It seems very reasonable to me that they can be remedied within that period of time, contingent upon the city responding in a timely manner to the permit application. And so, and if we come back, if that's not able to happen in 30 days because of that, and we're back here, I will give due consideration to that before any final penalty or anything like that is imposed. So after that 30 days, a $50 fine will begin to accrue. If something happens on the city's part that can't happen, I'm sure we'll be back here to consider adjusting that accordingly. So understand clearly that no fine or penalty will start to accrue on this until 30 days after I sign the order
Right.
relating to this.
Can
So-
we have 90 days on the construction equipment just to give it enough time to get the permit and have them build it without having to, I mean, I've already spent
Well,
so
the
much
no-
money extra on this stuff because of, there was no.
You're asking for 90 days to
On
complete?
just the construction
Oh, okay.
permit, or just the construction materials.
Let's make sure we understand this. On the construction materials?
Yes. I
Storing-
have nowhere to put them. I mean, I had everything lined up and did it in a timely and orderly fashion to
Yeah.
get
Mr.
it
Wolf,
done.
do you have a response to that request?
Mr. Chair, Your Honor, we would
Fine.
not support construction materials being stored in the right-of-way. Suppose a brush truck had to get to the woods
Sure.
behind there,
Right.
we would not support that. There's room within his property or off the public right-of-way that could be placed.
Okay. All right. And I agree, and I don't think I have any jurisdiction to give permission for the use of public right-of-way, which I think is basically what I'm being asked to do. So what I do think I can do is give you a certain amount of time to remedy the violation, but I do think 30 days is reasonable for that. So that's what my order is going to be, is finding a violation on the three issues, as I've already stated. I'm going to allow 30 days from the time that I sign the order for that to be remedied, for those three violations to be remedied. No fine will start until after that 30 days, and I will order the imposition of $120 of prosecution cost. And we have your address, and you received mail at the address you've given us?
Yes, sir.
Okay, so we'll proceed with that, and you'll receive a copy of the order when it is entered.
Okay.
Thank you. Are we ready to go back to case one, or should we proceed to case three?
I'm ready, Your Honor.
Okay.
This one here.
So what'd you find?
And Your Honor, I'm going to go ahead and give you a copy of ordinance 2019-13. This is the ordinance that Commissioner Martin is referencing in his notes.
Yes, it's easier for you. 2019-13. So I think the confusion here is just the different types of fees that would be implemented. What 2019-13 does in section 4.2.4, which is on page 2 of the
Hang on,
ordinance.
Let me cross-reference that. Okay, so we're referring to, I'm trying to find this in your code of ordinances, so we're dealing with section 4. Hang on. Well, all of these in section 4 dot something. Okay, so tell me what page we're looking at in this ordinance. that's pertinent.
It's page 2 of the ordinance, and we're referencing section 4.2.4, accessory uses and structures.
Okay, and where would I find that in the City of Newberry Code of Ordinances? Never mind, I'm getting to it. Appendix B is the land development regulations. And Article 4 is zoning regulations. And there's 4.2, okay. Okay. All right, okay, so step me through it.
And so 2019-13, the modification that it made as far as temporary structures such as utility sheds is it eliminated the requirement to apply for a variance in order to put a temporary shed in the setback. So it skipped that part of the process. It didn't actually waive building fees for installing
Okay,
a
so
structure.
restate, let me see if I can make sure I'm understanding this. So 4.2.4 was amended. I see under parentheses 3, it says that temporary structures such as utility sheds that are not permanently mounted on a foundation or slab may be placed in a rear yard within 5 feet of any property line. And what you're saying to me is prior to this changed language, that they were required to get a variance
Yes, sir.
for that type of a placement.
Yes, sir. And so they had I believe it was $200 to apply for a variance, and then you go through.
$200 application fee is the public advertising. And the ordinance did, before that, they had to, temporary sheds had to be within the setback, period. And now they're allowed to be within 5 feet of the rear yard line,
Okay,
if they're temporary,
Right, so not on a
okay,
foundation.
so what I,
without getting a variance.
all right, so what I'm hearing is that the permit application that Commissioner Martin was talking about in this document that I've been provided, it was a variance permit application
That's correct.
having to do with where the shed could be situated on the property.
Yes, sir.
It didn't have to do with the actual, let me get to the language. It did not amend Chapter 14, Building and Building Regulations, that require a building permit for, quote, the construction, alter, repair, remove, or demolish, or to commence construction, alteration, repair, remove, or demolition without first obtaining a formal permit. That's the operative language we're looking at, right?
Yes, sir.
Mr. Stockman, I think you can probably comment on this. Separate from Chapter 14 of the city's building regulations, would the Florida Building Code require a permit for an application for the placement of that shed?
It does require that, and different municipalities interpret it different as far as the size of the shed that they start requiring it.
Right.
I know Gilchrist County lets you put a rather large pre-manufactured shed without a permit, until it gets a certain square footage, but
Right.
City of Newberry is a little more stringent on that. I know City of Gainesville is. Just about everywhere requires the zoning and planning approval to meet the setbacks, and then if it's site built, it always requires a permit. If it's a prefab that's over a certain size, depending on where you're at, it also requires it.
Okay, and you've already testified that, that if there was electric service, that would require a separate
Separate
application
permit.
and permit also.
Right.
All right. Ma'am? Okay, do you understand our conversation, what we're talking about?
I
The-
understand the conversation, but the shed store that does business right here in the city of Newberry, they're selling the sheds, they should be required to do a permit.
I understand, so I understand clearly what you're saying. So, let me ask this question. Mr. Wolf, and I think you've already answered this, but Mr. Wolf, today is the first time you have seen this document, is that correct? In this context?
Your Honor, that's correct. And just as something to add, we have contacted several shed companies.
Right?
And typically, their response has been, we're just selling merchandise, and they put it in either their contract or their invoice that the property owner is responsible for obtaining all permits.
All right. So, ma'am, who placed this shed on your property?
The shed store,
They actually brought it out and placed it on your property?
yes, sir.
Okay, is there, the trench that they're talking about, is that for the purpose of running electricity to the
Yes, sir.
shed? And who did that?
I did that.
You did that yourself?
Mhm.
Okay, all right. Mr. Wolf, what's your thought process? What do you think, Mr. Wolf?
If they put it in their invoice or their contract, that it's the responsibility of the homeowner or the property owner,
Well,
I
I've
would
just,
think.
I'm reading I'm reading the ordinance language. It says it should be unlawful for any person to construct. And I've heard testimony that it was the shed company that constructed and that placed it. electrics aside, that's another story, but I'm talking about the actual placement of the shed. I understand that I'm being asked to leave it upon the owner to deal with the contractor to deal with this, but I do understand what the owner was told by who she bought it from. I'd like to request, and I'd like Mr. Wolf, I guess I'd like a response from you, that if we continue this until we can notice the shed company and have them here to answer to this violation, that's what I'm kind of leaning to do, so that we can make all the parties responsible for this be present to answer as to why they think that there's not a permit required here.
Your Honor, my concern is that a building contractor is licensed under the Florida Department of Business and Professional Regulation.
Correct?
They are required to get a license and comply with their requirements.
Mm-hmm.
A store that sells sheds is not a licensed contractor.
Understand?
They're not required to meet the requirements of Department of Business and Professional Regulation.
Right.
So I would think that they're selling a product, and it's not within our authority. If they sell a product to a person and then the person buys it and has it delivered, ultimately the property owner is responsible.
I
That's our
agree.
position.
I agree. I don't think that the property owner is relieved of responsibility, but I do think that, number one, your code is written, I think, to make whoever places that they're responsible. And I guess I'll say it this way. What I'm hearing today as far as the testimony is not only did this company sell the shed, but they also placed the shed.
Mhm.
So they're doing more than just selling it and her picking up. Now, I want to make sure I understand. You're saying that they delivered the shed and they placed the shed where the shed is currently located.
Yes, sir.
Okay. And we've got the other issue here that the testimony indicates that that business affirmatively told the owner that a permit would not be required. So that, in my mind, that adds some more responsibility on their part. Is the shed company actually situated within the city? Do you know?
Yes.
You say it is, Mr. Wolf? Do you know?
I believe it is.
Yeah. I'd like to continue this to the point that, I'd like to continue this hearing to the point that the shed company, that code enforcement can determine whether whether code enforcement should cite, in addition to the owner, the shed company. Under the language, I'll defer to the code enforcement working with the attorney as to where that interpretation is appropriate. And I'd like to, and before I render an order on this, I would like to be looking at the owner and the shed company in the eye about how this all came down. So,
Okay. And, Your Honor, we had not received anything proving that
that's
where it
what-
was purchased. So I can't cite someone that I'm not aware of. And I did ask Ms. Hall if she could provide me the information about who said she didn't need a permit, and she
Right.
said she would give it to you, but not to me.
Right, I got it. And that's why I asked you, had you seen this before today? So, so I think that's going to be my order. I'm going to continue this to a point that hopefully the shed company and the owner can be here to explain what's going on. Meantime, I would suggest that the owner goes back to the shed company and lets them know what's fixing to happen, what could be fixing to happen, and maybe y'all can work out who is going to pay for the application of the permit. I'm not making a decision today about a violation. Well, no, I'm not going to make a decision today about the violation until maybe we can have both the parties here before this hearing. But again, they need to know that that the testimony and what I'm seeing, buttressed by the city attorney explanation, is that a permit is required. And maybe they will agree to help be responsible to you for giving you bad information. Okay?
And Your Honor, now that under oath, the property owner has admitted that there is electrical
I
installed.
am going to find a violation as to not obtaining a permit for the electric service, and I'll give you 30 days, the owner 30 days to remedy that permit requirement. So you'll need to work with the city to apply for a permit for the electric service, which is going to trigger an inspection from the city for for the electric service being appropriately installed, and I don't know where that will lead to, but that's not in front of me today. So you, Mr. Stockman, you would agree with how I stated that, right? Yes, okay. Okay?
Okay.
All right.
Just to clarify, so you're not finding a violation, you're not,
I'm finding a violation of no permit
for the electric?
for the electric service,
Right.
and the owner, and that will be just the owner, and that will be up to the owner to remedy within 30 days from the date, and a $50 fine will begin 30 days after my order, understanding that the remedy of no permit is that the owner needs to come in and apply for a permit for the electric service that will remedy that violation. Where that application leads is a different story.
And no administrative fees?
No administrative fees at this point yet. Okay. Moving on. Case number 2020-003, City of Newberry versus Blair and Gibbs. And I want to make sure on the owner's name there, that's Blair Ayers. So maybe meaning
Yes, sir.
heirs of an estate. Okay. All right.
Your Honor, again, I'm Rick Wolf, Code Enforcement Officer with City of Newberry, and I've been duly sworn, and my credentials are on file with the clerk. In case CE 2020-003, the respondents are Blair, Ayers, and Gibbs as the property owner, and John Blair, who is the tenant, as the responsible party. The photographs I will be presenting into evidence today are accurately representing the violation as seen and were taken by me on the dates indicated on each photograph. On the 20th day of February 2018, the City of Newberry received a citizen complaint on developed mobile home lot at 24716 Newberry Lane in Newberry, Florida, on tax parcel 01918-007-000. The property owner was inspected by me on, the property was inspected by me on February 20th, 2018, and was found to be in the incorporated city limits of the City of Newberry and in violation of City Code of Ordinances for Chapter 94, Article 5, Section 94-124 for wrecked or non-operating vehicles on private property, in that no person in charge of control of any property within the city, whether an owner, tenant, occupant, leasee, or otherwise, shall allow any partially dismantled, non-operating, wrecked, junked, or discarded vehicle to remain on the subject property longer than 72 hours. And no person shall leave any such vehicle on property within the city for no longer than period 72 hours, except that this article shall not apply with regard to a vehicle in an enclosed building, a vehicle on premises of a business enterprise operating in a lawful place and manner when necessary to the operation of such business enterprise, or a vehicle in an appropriate storage place or depository maintaining in a lawful and manner by the city. And also Appendix B of the Land Development Regulations, Article 4, relating to zoning regulations, Section 4.2, Supplemental District Regulations for 4.2.17, parking and storage of certain vehicles. In residential districts, automotive vehicles or trailers without any type of current license plates shall not be parked or stored other than in a completely enclosed building. And Appendix B, land development regulations for minimum housing requirements, sanitation requirements, Section 9.24.4, care of premises. It shall be unlawful for owners or occupants of a residential building, structure, or property to utilize the premises of such residential property for the open storage of any abandoned motor vehicle, icebox, refrigerator, stove, glass, building material, building rubbish, or similar items. It shall be the duty and responsibility of each owner or occupant to keep the premises of such residential property clean and to remove from the premises all such abandoned items as listed, including but not limited to weeds, dead trees, trash, garbage, etc. The property that we're referring to is zoned residential mixed unit single family and mobile home, RSF MH2, and is approximately 0.2 acres in size. I'd like to show you some photographs at this time. Yeah, this was a photograph first taken back in May of 2018, showing some of the inoperable and unlicensed vehicles and some of the appliances, lawnmowers, vegetative debris, etc. Next slide. This was taken on March 6, 2019, showing a multitude of appliances. Mr. Blair, the resident of the property, have been known in past years to be a person that could fix any kind of appliance, and people would bring him appliances and he would fix them and sell them, and accumulated quite a collection of appliances for which they would come and go during different times of year. But there would always be a multitude of appliances, including everything but and the kitchen sink. So next slide. Here you see in March 19th, 2019, March 6th, tires, again, junk and debris, and unlicensed vehicles. Next slide. This was taken also on March 16th at the front of the property. You see sitting out right in the front yard, a toilet, a microwave, a little wagon, bicycles, appliances, furniture, and that again was on March 19th, 2019. Mr. Blair had been working, this wasn't something that accumulated in a day, and has been here for several years, and I had been working with him to try to get him to come into compliance, and he was making progress slowly but surely for a long while. He did have some health problems, and that resulted in having to slow down on getting some of this taken care of. Next slide. This was on March 6, 2019, when the original notice of violation was posted on the property. We had trouble getting service, so we posted the notice of violation on March 6, 2019, and again gave him extensive amount of time and continued giving him extensions because some progress was being made. Next slide. Going to April 16, 2019, again, unlicensed vehicles, stack of windows, appliances, lawnmowers, and you can see in the middle of the picture on the left the kitchen sink. Next slide. Again, junk vehicles, lawnmowers, unlicensed vehicles, and tires. This was on October 1st, 2019. Next slide. October 1st, 2019, again, this was in the front yard, appliances, trash and debris, an air conditioner on the front porch. And next slide. Another October 15th, 2019, you see another vehicle on the property that's inoperable. Appliances on the slide to the right. In the front yard on September 2nd, 2020, trailers in the front yard. There was batteries, there was furniture, there was appliances, and you can see on the front deck on each side of the doorway there's 2 refrigerators outside exposed. Next slide. Again, more appliances, bicycles, tires, and 3 more refrigerators that were there, that weren't there the month before. So things keep coming and going, but they're all being stored outside within the yard. And next slide. Again, you see wagons, lawnmowers, tires, bicycles, toilets, just a large collection of abandoned or junk materials. And the next slide. This was the day that we posted the property. Mr. Blair did have some of these appliances put on a trailer, and from time to time had been hauling some of this away. On the right slide, back in the back, if you follow that dirt road, that's where 3 more vehicles were, and then that truck on the right side is now inoperable at this time. And that was September 29th. Next slide. Also on the 29th, there's another trailer load of stuff being ready to be hauled away. So at times, some efforts were being made to remove some of this material from the property. Next slide. Again, things keep being moved around, but you can see in the front yard, there's things that just shouldn't be there. And the next slide. This is the posting of the property. You can still see the 2 refrigerators on the front porch. On that railroad tire or piece of wood, there's about 6 or 8 batteries, car batteries that are being stored out there in the front yard. So these are items that are not allowed to be there in terms of care of premises. And the next slide is the posting at City Hall. And the next slide is taken on October 13th, which is the day that I did the inspections for compliance. And again, a large amount of appliances, trash and debris, and unserviceable vehicles. And this also on October 13th, appliances, bicycles, and some other stuff that has been loaded on a wagon. And again, the front yard, this is on the picture on the left side is a truck with both front tires off, inoperable, and you can see 3 vehicles to the rear also. And lawnmowers, piles of cans, it's just in an unkept care of premises for a good 2 years. And this has been an ongoing situation where we've tried to work with the property owner or the tenant to make some progress and get this taken care of, and I think it's kind of at times overwhelmed him. And final slide. Again, appliances sitting in the front yard, not in compliance. So, Your Honor, the notice of violation that was sent out on March 6, 2019 to the owner of record as recorded in the tax collector's office and other responsible parties as the code allows. This notice was posted at 24716 Newberry Lane, where John Blair resides, and the notice of hearing was mailed by certified mail on September 23, 2020, and the notice of hearing was also posted at City Hall and on the property at September 29th, 2020. Notice and posting was done by both certified mail and posting. This property is currently not homesteaded at this time. In the notice of violation, the respondent was giving originally May 7th, 2019 to correct the violation, to repair and provide current license tags for vehicles or remove them from the property, to remove appliances and furniture in the yard, and to clean up the junk and debris and remove from the property, and remove all items from adjacent parcels, including the CSX Railroad right-of-way. The property contained unlicensed and inoperable vehicles parked both in his yard and on adjacent properties. trash and auto parts, appliances, junk, and debris on this property and on adjacent properties attributed to Mr. Blair. It's noted that several extensions of time were given due to the amount of material and some response he had taken to clean it up. However, the property still remains in violation. The result of my inspections on May 23rd, 2018, March 6th, 2019, April 16th, 2019, October 1st, and October 15th, 2019, September 2nd, 2020, September 29th, 2020, October 13th, 2020, and October 20, 2020. Staff recommends a finding of in violation for the respondents Blair and Gibbs heirs as the property owner, and John Blair for the responsible party for violation of Chapter 94, Article 5, Section 94-124 for wrecked or inoperable vehicles on private property, zoning regulations for Appendix B, Section 4.2.17 for parking and storage of vehicles not being licensed, and Appendix B for sanitary requirements under the minimum housing regulations for care of premises. And we recommend that the respondent be given 60 days to comply as per the original corrective action stated in the original notice of violation, or a fine of 50 days per day per violation until compliance is achieved. And we also request that further that the City of Newberry recover the prosecution cost of $120 for prosecution. And that concludes staff's comments. Be happy to answer any.
Recommendation, I believe I heard you say $50 per day per violation. What are you anticipating the per violation would be?
Well, there are
Three
essentially
sections.
three violations listed. Inoperable vehicles, unlicensed vehicles, and the care of premises.
Okay. All right. Do you have evidence where you need to submit?
Oh, yes, the photographs. Copies of the photographs that were shown.
Okay, do we have anybody here on behalf of the owners?
Yes.
You can step forward. Okay. And yes, ma'am, your name is?
I'm Joy Ingram.
Joy Ingram?
Mm-hmm.
Okay. And what's your relationship?
That's my
To-
brother.
And the gentleman in the back is who?
That's my brother, the owner.
John Blair.
John Blair.
Okay, so he is John Blair. Okay.
Yes.
All right. So you've heard the testimony of Mr. Wolf. Yeah, is that? Pardon?
Nothing. Hold on.
Okay. So you've heard the testimony of Mr. Wolf, and you've seen the pictures. Is that representative of the condition of the property?
Some of it. It have been, we have moved some of the cars. 2 of the cars I know have been moved, and 1 more gonna be moved. We is working on the property. I'm helping him out right now. I have took 2 loads of, the refrigerators and everything away. We do have some already loaded up to go again, but we is working on cleaning up the property. But like he said, stuff coming, the city of Newberry don't have the right proper garbage. So people feel like they can come and just drop stuff off because the city of Newberry don't have the right garbage to pick up. If somebody put a washing machine or something inside the road, the garbage can not gonna get it, so they takes it out there to him. And so he do collect it, and then, but some days he there, they just drop it out. So, but we is, doing the best we can, and we is get rid of the stuff.
Right.
But I'm gonna get some signs, and I'm gonna put up on the property for nobody to be coming out there dumping.
Right.
So he do have a lot of stuff, like he say, but I can show you some pictures also where we have loaded, we have moved
Sure.
cars also.
Now,
We working on it.
Mr. Wolf testified that
Yeah.
you are working on it. So
Yeah,
I
we're
don't- I
working
don't-
on it, and like he said earlier, you know, yeah, he did have some health issues, and that slowed it down. But now I'm working on it.
Okay, so, Mr. Wolf you heard his recommendation that I enter an order allowing 60 days to get the rest of this cleaned up, and that a daily fine will begin after that 60 days.
Okay, I
So-
heard the 60 days.
Right.
Okay.
And he's
You can
at,
give- I can ask you to give us more than 60. You can give us at least 90 days. You have not never talked to me, so now I'm Joy Ingram when you're talking to me. So I am going to be taking care of everything I can at the earliest. And then if that not happen, then you can do whatever you got to do. So give me 90 days. That's a lot of stuff, and you know it.
Your Honor, if I could ask, what is the relationship between
sure, right. So what is, that's your brother?
That's my brother.
Okay,
I'm Joy Ingram. I'm his older sister.
Okay.
I'm Joy.
So let me answer my questions, and probably, I really don't want you interacting directly with Mr. Wolf unless he's okay with that, so. Okay, so you're your sister to Mr. Blair.
Yeah.
Do you have some ownership interest in this property?
It's Al's property.
Okay, so it belonged to like your parents or something like that, right?
Yeah, I was a Blair.
Okay, okay. And while we're on this subject, tell me, who is Gibbs?
She passed away.
That was another owner?
That was our aunt.
Okay, and so there's maybe some other children of your
We
aunt?
inherited the property.
Okay, right, okay. All right, do you have Mr. Wolf, do you have a response to the request for 90 days?
we would not object to that additional 30 days.
Yeah, okay,
30, 90 days.
all right,
Ensure compliance is,
Thank you.
okay, so,
God, he's not taking over the land. Be quiet.
so, okay, so Mr. Wolf initially requested 60 days, which we normally, the normal amount of time that I order for remedy of this is 30 days. So Mr. Wolf has already given an extra 30 days there. And based on your request and your assurance that it will be done in 90 days, I'm going to allow 90 days.
Thank you.
And understand that after that 90 days, that's when the $50 per day per violation kicks in.
Yes, sir.
So that's going to start, if it doesn't get done in 90 days, that's going to start running up pretty fast.
I
So,
understand.
okay. All right, and that 90 days will, okay, so what I'm going to do, if there's nothing else, what I'm going to do is I'm going to find a violation of Section 94-124, wrecked or non-operating vehicles on private property. I'm going to find a violation, I'm going to combine the violation of 94-124 and Section 4.2 of the Land Development Regs, because both of those deal with vehicles. So I'm going to consider that to be one violation. It is multiple vehicles. I could find a violation for every one of those vehicles, but I'm going to find one violation regarding vehicles, and that's going to be 94-124, and Section 4.2 of the Land Development Regs will be combined. Actually, that's Section 4.2.17. I'm going to find a separate violation of the Land Development Regs, Section 9.24, for all of the other appliances, furniture, other junk and debris that is on the property. And I'm going to allow 90 days for that to be remedied, at which time there will be a $50 per violation, which, for clarity, I'm finding two violations. So that will be $100 per day after the 90 days. And I'm also going to impose, include in the fine immediately, the $120 for the administration of this case. Anything further on this case that I need to think about?
Your Honor, I don't believe so.
Okay.
One thing we'd like to see occur if possible is to really concentrate on the vehicles first.
Yeah, I have, moved two. Okay, the ones where you said,
There's 2 or 3 that are actually over on the CSX.
I have the one, the gray one you seen on the other side of the white truck. Okay, I moved that one. I moved that one, but the white truck is still there, and the red one, what was up on the hill, he moved that one down. And then it was another little gray one, I already moved that one. I have moved 2. I know I moved 2, okay? But the third one, it'll be moved in a couple of weeks, because somebody said they want to buy it from this, like an antique car. Okay, so it will be moved.
Sounds like we're still making some progress.
Yeah,
Okay,
and I myself took my vehicle and moved some of the items and went to High Spring and took them. And so we got a couple of loads now, okay?
okay, that'll be it for this case.
Mhm.
Ms. Hall, I see you're still here.
She's family.
Okay, good, all right. Yeah, might have more to say. Okay. Okay, with that concludes our cases that are scheduled for today.
Okay, thank you.
Thank you.
I was gonna ask the same thing.
Comments from the special magistrate. I had a couple of things that I wanted to, just based on what's went on today, observe. Earlier you mentioned the problems y'all were having with certified mail getting delivered. And so I looked at the statute, it said, and y'all indicated you were relying on posting of the property as appropriate substitute service. I looked at the statute and I can't, just glancing at the statute, I can't tell if I think that posting is effective substitute service or whether it's just a secondary method, an additional method of getting service. So I don't think that mattered today because all of the, everybody appeared. There was somebody appearing on behalf of everybody, so I don't think service was an issue today. But I'd like the attorney to look at and assure, and assure me that posting is a separate effective method of service. Because if we have a case like this and nobody shows up, we have to rely on the posting being effective. So,
Your Honor, what my understanding is, and the Florida Association of Code Enforcement is dealing with this statewide, is that if we process certified registered mail return receipt requested, we've met our obligation to send certified mail. If that card comes back unsigned, means it was never delivered, unable to deliver.
Right.
If it comes back COVID-19, where the mailman attempted to deliver it, was successful but didn't get a signature.
right.
That's, to me, we complied with service. But just as an assurance, we've also posted and sent regular mail.
Sure.
So we've done all three.
Right, and I'd just like that to, maybe the attorney to give me something that buttresses that opinion. Are you saying that the Florida Association of Code Enforcement has dealt with this issue within COVID, as it relates to COVID?
Yes, because I
okay.
didn't sign the card.
All right, okay, all right, so, okay, all right. But I'd still like to get that from the attorney. And the other, what was the other issue? Well, now, the second issue, I got off track, mind off track, and it's escaping me now. Nope, can't remember what it was. So if I remember what it was, I'll communicate later with you on that. Okay, anything else? Okay, that's my comments. Any comments from staff? Okay, we'll stand adjourned.